my application for which
the application can only come after I have something.
Just a minute. What is it that you want us to do?
Permit me to make an application under the Mutunda rules that following the disclosure of the court this morning that was made by Justice Murima, that this Honorable Court does determine whether the Deputy Chief Justice has the power to empanel the bench under Article 165, Clause 4. Your Lordship, and whether, if she has any power of that nature, the same ought to be communicated to the members of the Republic by the Chief Justice, that is to say, Your Lordship, that the Chief Justice has delegated her powers under Article 165, Clause 4 to empanel this bench. Your Lordship, this is the background of my application. That on the 14th of October 2024, the Honorable Chief Justice did empanel this bench to hear and adjudicate over 6 matters which were consolidated with the lead file being 522. And the files that were consolidated, Your Lordships, my lady, were 522, 509, 537, 528, 525, and 506. Your Lordship, it is our humble submissions that this bench was exclusively empaneled to handle those files, and that the communication was effectively made to the parties by the Honorable Chief Justice. I am giving the background of my application, and that we are aware that subsequently other files, and the most important one is E014 of 2024, which came from Ongoya, was equally slated for empanelment before the Chief Justice. To date, Your Lordship, there is no communication from the Office of the Chief Justice other than this morning that this file was equally empaneled and designated for hearing for this bench. Your Lordship, the other ground is this, Your Lordship, that when we appeared before you on the 16th of October, Your Lordship, we sought your indulgence, Your Lordship, to have a further mention on the 18th of October.
My Lord, I'm sorry we are constrained to interject to seek your guidance. My name is Mudomi, appearing for Professor Kibiki. Listening to my colleagues, he is making an application before this bench, complaining about wrongs supposedly made by the Chief Justice and the Deputy Chief Justice in bringing us to this session of today. For me, the clarification I wish the court to provide is whether an application of that nature can be made informally without the CJ and the BCJ being made parties to that application and being offered an opportunity to explain, so that to be fair on these state officers, it's easy to speak to the gallery and cast all manner of insinuations and aspersions against them. And if my Lord finds that an application of that nature cannot be made informally without actually filing a formal application and joining the CJ and the BCJ so that they have a chance to respond to these insinuations, I suggest again, and I beg the court, I'm a very junior counsel, but Professor Mugai wonders that we run the risk of coming to a court of law to speak to the gallery in parliamentary language, what I fear is happening is what is called filibustering, my lord. To filibuster is where you go to a forum intended to deal with the business of the day, and you keep making speeches upon speeches that have no bearing on the business of the day, where the motive is to ensure that the business of the day is not conducted. To the best of my knowledge, the business of the day, there were applications on their side, there were applications on our side, and the court was graceful enough to give both sides an opportunity to come today to ventilate those applications. Instead, we've lost 2 hours, my lord. We've not been addressed on those applications. We are just filibustering.
My lord, perhaps if I may.
Yes. Yes, Mr.
My lord, you are being invited to interpret Articles 161 and 163, 1B, 1 and 2, which designate the Chief Justice and the Deputy Chief Justice as head and deputy head of the judiciary. And you are being asked to inquire into the manner that they perform their duties as head of the judiciary and to interpret Article 165(4). That can only be a substantive, through a substantive application to which all parties must respond. I think my concern then, and Edward and my friend Kibe, is that you are taking the court for a long ride and we are ending up wasting a lot of time in court. I wish you could go to the issues. If the question is, if you are ending up with an application for the disqualification of the bench, why can't you go to that point instead of beating around the bush, as you would say? My lord, if I may, just to bring it to the court's attention, that the issue that my learned colleagues have taken up rather dramatically this morning is an issue that they have taken up with the Chief Justice by way of a letter. Before they came to court, they have taken up those issues with the Chief Justice by way of a letter. If that is the avenue that they have chosen, then let them deal with it by way of the letter. It isn't anything that should take your lordship's time. That letter remains. They have written it to the Chief Justice. We have been copied on the letter, and we await the learned Chief Justice's response to the letter. It isn't anything that should take up time this morning.
My name is my name is Manjur Modi. I am acting in person. We filed an application of a certificate of urgency on the 8th of October, 2024. Before this bench was impaneled on the 14th of October, 2024. Unfortunately, some of the prayers we were seeking have been overtaken by events. My Lord, and today, as we have heard, our applications have not been placed before you, and we are just concerned that our application will once again overtake our application. My Lords and my lady. So we are asking with your kind indulgence, if you would please at least allow us time, my Lords and my lady, for our application to be consolidated and heard together with the other applications that have been heard today.
My Lords and lady, for the 15th President Party in 15, may I just be heard for 1 minute only. My Lord Judge, asked an important question. How do we move forward? The paradox as I got it, because I don't make speeches, is that my colleagues accused this side of making speeches, and in the process they made speeches. But having said that, my Lord, an issue has arisen following disclosures by my Lord Justice Mrima about how this bench has been constituted. It's now apparent that the petitioner and the first interested party in petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here. And since that issue goes to the core of your capacity seat, it ought to be resolved preliminarily. Whether you have been properly empaneled is the most preliminary of preliminary issues. We urge that you give direction in the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date to come and canvass that application on whether you are properly constituted. Because if it turns out that you are improperly constituted, even the issue of recusal becomes secondary. But if it comes out that you are properly constituted, then the issue of recusal now follows. I urge that if we follow that route, in accordance with my teacher's guidance, Professor Gachagua, there will be greater order and coherence. And I thank you.
My Lord, is that an adjournment? Is that if Mr. Ongoya applying for an adjournment because he's saying, and perhaps rightly or wrongly, that even the recusal application comes after the termination of the question when panel. If that is so, and they may leave, they normally leave court, they may leave, they left Senate, may leave court, we let them say whether they apply for an adjournment.
Is that remark, they normally leave court, whether they left Senate, my palatable in this court, my Lord? I need that.
No, because it's an adjournment.
No, is that remark palatable before my Lord and my Lady? My Lord, because, you know, we have decorum at the bar. If you have a professor of law misbehaving at the bar, then there's a problem. I'm urging that you direct that remark to be withdrawn first, then we make progress. I'm urging, my Lord. The remark was made in your presence. I'm urging it to be withdrawn first, then I can respond.
My Lord, I have no problem with withdrawing the remark, but the point is, it is a veiled application for adjournment. Because Mr. Ongoya is saying that the court must address the question of empanelment before the recusal. So why can't we just get to the point?
I am answering the question now, but I know that he has withdrawn. He said he has no problem with withdrawing, but didn't withdraw. I want him to withdraw first, my Lord, because I'm trying to do it.
Ongoya, I have no problem with withdrawing. You're my friend, but no, I have no problem, my Lord. I withdraw the remark,
Thank
but
you so much. Thank you.
there is practice.
Thank you. Let me now address the question as addressed. My Lord, Professor Agenda was my teacher and been my mentor many years. I have no disrespect for him. I just want my own dignity asserted because I can't protect my client's dignity if my own is in question. But having said that, my Lord Judge Mrima, you are a witness that the issue of how this bench was empaneled has been disclosed here when we are here. We have raised concerns through learned colleagues, Ongoya, and learned colleague, Mr. Ndegwa, that we now want to take that as an issue. My colleagues have rightfully submitted that that matter requires a substantive application. Rightly, we agree with them fully. But you'll agree with me that if you are improperly constituted, then you cannot make one more step. It's therefore in that regard that my Lord Judge Mrima asked, how do we move forward? I also had my learned mentor, Professor Gachagua, again ask, how do we move in an orderly manner? I'm suggesting let that substantive application be placed before you. Being as preliminary as it appears on the face of it, give back-to-back timelines on the compliance by the parties. Let the parties come and now formally address you on that question. They'll have a determination on that question. I humbly believe.
Let's have the issues from this side and then the
Thank you. Allow me, my lords and my lady, to address the issue of disclosure, which is actually being attributed to Mr. Justice Mrima. And sometimes it's good to tell the truth, because the issue of how this bench was empaneled has not come to light. It is now. They actually knew of it, and this, or should have, they would have found out. The letter, which was written this morning, which we have, it was received on that, it was written on the 20th of October, as actually one pertinent question. It is posed whether the file was actually taken to the Chief Justice and at what time. So, they are actually knowing something regarding that. Then we are dealing with constitutional functions under Article 165(4), which means they were saying only the Chief Justice can constitute this bench. So they actually knew how the bench was constituted, and then possibly the only reason we should be given is why the file was taken to DCJ, possibly because of the absence of the Chief Justice. They will have to take themselves to why we have the Chief Justice being the head of the judiciary and the Deputy Chief Justice being the deputy head of the judiciary. In the absence, that's what the Constitution provides. In the absence of the Chief Justice, it is the Deputy Chief Justice who is supposed to do administrative work, which, and here, let's not filibuster what we were told. But as we do in the Parliament, you go around in circles to waste time so that the motion possibly is defeated by evolution of time, which is what they are trying to do. The truth is this: it is well known in practice that the court's administrative functions can be done at any time of the day. including this bench, can sit up to midnight without anybody questioning. So the issue when the Chief Justice, Deputy Chief Justice sat, does not arise. As to what happened on Saturday, again, this is purely administrative.
For the Speaker of the Senate, may we be heard?
Yes.
My Lord, allow me to assist the court. And my Lord, listening to the speech, not an application made by my colleagues on the petitioner side, my Lord, I just want to state that the Deputy President filed his petition on Friday. And my Lord, on the same day, he got conservatory orders. My Lord, he accessed justice in accordance with the framework in Article 48 of the Constitution. But my Lord, justice cuts both ways. My Lord, the respondents on the same day filed an application to set aside those conservatory orders. My Lord, properly constituted, this court has issued directions that those applications be heard today. My Lord, under the Mutunga rules, there is a fundamental doctrine which we are all missing. The doctrine of timely resolution of such kind of disputes, especially disputes that are of immense public interest. So, my Lord, if you look at the application which has been made, or speech made by the petitioners, my Lord, you will see that they want to split hairs. My Lord, the Constitution expressly provides that the Chief Justice shall appoint a bench to sit on matters which raise substantial questions of law. But my Lord, at the same time, that Constitution which requires to be read conjunctively says the Deputy Chief Justice shall deputize the Chief Justice. So my Lord, what is the fuss about it? So my Lord, my request is that the application is speech by the petitioners is solely meant to delay the business of the day. And my Lord, I request in public interest, my Lord, I request in public interest that you give directions. We proceed with the application. We are here on the application for conservatory orders. And my Lord, you also hear our application to set aside the conservatory orders. My Lord, that will make juridical sense and promote public interest. Thank you.
My Lord, if I may just add, this court has the control of the proceedings.
And this is a very weighty matter. It concerns the Deputy President of this country. I will not allow everybody to speak, because if everybody is going to speak, we are going to head nowhere. A challenge has been posed on the validity of this bench to sit. This is the direction we are making. The application challenging the validity of this court to sit must be filed within 1 hour and responded to within 1 hour. We will come at 2 to listen to that application.